Hello everyone, welcome to yet another session for the daily news analysis by SRIRAM'S IAS, where we take up the important articles featuring in the Hindu newspaper and break them down for our understanding from the examination point of view. Let's start today's discussion by taking up the important articles. The articles that we've taken up from today's newspaper appears on the screen. Let's start with the first article for the day. The first article which appears in the newspaper reads the new guidelines to prevent unfair trade practices. Now, this particular article talks about the Consumer Protection Act and the body that is instituted under the Consumer Protection Act, that is the Central Consumer Protection Authority, which is the newly instituted body under the renewed Consumer Protection Act of 2019, and that body has issued guidelines to prevent unfair trade practices. So we will understand what is unfair trade practices, and the particular unfair trade practice that is being talked about in the article is the concept of service charge, which is levied by the restaurants and other such outlets. So we'll be understanding this issue of service charge and how is it connected with the Consumer Protection Act. So this becomes important for us to study from the GS2 point of view, where we study various acts, and also GS3, where we look at important aspects of the economy and market. So first let's try and understand what is a service charge. Now there is something known as service tax. Service tax is different from service charge. So how do we understand service charge? Service charge is nothing but the tip. It can be understood as the tip that we generally give to the restaurants, the service providers, over and above what we pay for the food and whatever we order and we eat. So when we go in a restaurant, order in any food item or beverage from the menu, and apart from the price, that is the maximum retail price of that product, we pay the tax, that is now the GST on that particular food and beverage. So after us paying the amount of that product and the GST, the price of that product is according to the law fixed over there. Over and above this price, that of the price of the food and beverage and the tax levied upon it, over and above, if some amount is accrued to that, is known as the service charge. So what is it? It is the tip and is equivalent to what is known as gratuity. So this is something which is over and above what we pay when we go into a restaurant and order any food and beverage. So it is found printed at the bottom of the menu and is identifiable from the asterisk mark. Why is there an asterisk with respect to the service charge? We'll understand this because it is generally decided by the restaurants on their own. So since it's the tip, since it's an amount over and above what we're eating, it is decided generally by the restaurants themselves. And as per law, GST is a mandatory component of the restaurant bill. However, the service charge is an optional component. So here comes the catch with respect to the payment of the bill, whatever comes, the amount for the food, the tax on it, which earlier used to be the service tax, now is collectively known as the GST. That is mandatory, but any service charge levied by the restaurant themselves is an optional component, which means that the restaurant cannot compel the consumer who has come to eat or to dine in his or her restaurant. He cannot compel the consumer to pay this service charge. So, and amounting this service charge, compelling the consumer to pay this service charge, is what has been identified as an unfair trade practice. So what do we mean by unfair trade practice? So the Consumer Protection Act of 2019, which was renewed, and the earlier version was Consumer Protection Act 1986. The initial act came in 1986 and the renewed act came in 2019. This particular Consumer Protection Act is being promulgated to take care of the rights and interests of the consumers, right? So consumers are there in the market who go and buy any service or product, so they need to be protected with respect to the quality of the product and service given to them. It needs to be taken care that no fraud or no unfair practice is carried on with them. So in order to protection of these rights and interests, the Consumer Protection Act of 1986 and 2019 was promulgated, which took care of these things. So it's defined unfair trade practices as those kind of practices which are carried on by the manufacturer or the retailer, which are in sort of, one can say, to the disregard or non-benefit of the consumer. The consumer is either facing some kind of a loss through it or being deceived by it. So let's say that if any product manufacturer is using any harmful chemicals and they are not disclosing the ingredients of those chemicals that are being used in their packaging, so this amounts to unfair trade practice. Let's say that one product manufacturer or service provider gives a guarantee to the consumer, but that guarantee is not at all accurately measured and thought of, and it's just given so that the purpose of guarantee is fulfilled. This amounts to an unfair trade practices. So all such practices which the manufacturers and retailers carry on to deceive the customer or can result into deceiving the customer to their drawback is known as the unfair trade practice. So now the Central Consumer Protection Authority, or the CCPA, which was instituted under the Consumer Protection Act 2019, has now identified the levying of service charge by these restaurant owners on their own and compelling the consumers to pay them as a unfair trade practice. And that is why it has issued guidelines for the restaurant owners to not levy such service charge, and if at all they levy, they cannot compel the consumers to pay that service charge. So something about the provisions, let's see first. So the Consumer Affairs Ministry, this is under which the Consumer Protection CCPA, that is the Central Consumer Protection Authority, functions under. So it put out the guidelines on fair trade practices related to charging of service charge from consumers by hotels/restaurants in 2017. So first set of guidelines came in 2017, wherein it said that the service charge component is inherent in the provision of food and beverage, and hence the product's pricing is to cover the both components, goods and service. What this meant was that the reason behind keeping service charge optional was that whatever amount the restaurant is keeping for the food and beverage on its menu, it already has the cost of the making the food as well as the service that would be given by the service staff of the restaurant. So that particular amount already carries the charge of both these things. That is why an extra service charge cannot be held as mandatory, and therefore charging tips in the name of service charges without the customer's express consent amounts to unfair trade practice, is what came out as the guidelines by the ministry. And therefore the food bill may clearly display that service charge is voluntary, and the service charge column could be left blank for the customer to fill before paying the bill. This means that one has to inform the consumer that the service charge is voluntary and he or she might choose to not pay it. And recently, the Central Consumer Protection Authority has issued fresh guidelines, because the menace of service charge, one can say, is going on, and a lot of cases are going unseen and underreported, where consumers do not know their rights related to the service charge. And that is why in the food bill, the restaurants are levying the service charge without the knowledge to the consumers that they are not compelled to pay it. So the fresh guidelines say that the restaurants cannot add service charges by default, and they cannot be collected under any other name. So if other than the service charge they have any other name, such as the convenience fee or any other name that they can put to these put to this extra charge, that also they cannot do. The other is, restaurants can't force consumers to pay service charges and are required to communicate these charges that they are optional, right? This we saw. And restaurants cannot restrict the entry or provision of services to consumers based on the service charge collections, which means that based on the consumer's will to pay or not pay the service charge, he or she cannot be compelled to restrict the entry of that consumer into the restaurant. So, and then service charge can't be collected by adding it to the food bill and levying GST on the entire amount as well. So this also cannot be done, where you levy the service charge initially with the amount, and onto that whole amount GST is added. That also cannot be done. And any complaints relating to this levying of service charge and mandatory asking to pay the complaints can be lodged via the National Consumer Helpline or NCH or on the number 1915 or the NCH app or e-Dakhil portal. This is the mechanism, grievance redressal mechanism instituted by the CCA to take care of these complaints. Right? So this was the issue relating to the new guidelines pertaining to the service charge which is levied by the restaurants, which is optional, and they cannot compel the consumers to pay it. And talking about the Central Consumer Protection Authority, let's look at some of the pointers for the Central Consumer Protection Authority as well, which becomes important for us from the examination point of view. So CCPA is a regulatory body established in 2020 based on the provisions of the Consumer Protection Act 2019. Like I said, this is the renewed act after the 1986 Act, which was promulgated to strengthen the provisions of consumer protection laws, and it works under the administrative control of Ministry of Consumer Affairs, right? So this authority takes care of all the objectives that are there to safeguard the rights and interests of the consumers, that is to promote, protect and enforce the rights, to conduct investigations into violation of these consumer rights and institute complaints and take care of their prosecution, and to order the recall of unsafe goods and services and discontinuation of unfair trade practices and misleading advertisements, and to impose penalties on manufacturers, endorsers, publishers of misleading advertisements. So all of these acts fall under the purview of the CCPA or Central Consumer Protection Authority under the Consumer Protection Act. So this was a discussion related to this topic. With this, let's move on to our next topic for the day. The next topic which appears in the newspaper reads, MPs panel oppose mediation bill. Now this becomes an important issue for us because the concept of mediation is quite in discussion, and it is being talked about in the in the legal sphere, where it is touted as the next revolution with respect to dispute resolution or what we call resolving of cases. So it is being touted as the next big revolution which can occur in the legal sphere. So with that, in that aspect, we'll discuss the mediation bill and what are the issues that are being flagged by the Parliamentary Standing Committee. So we'll look at that. This becomes important for us from the perspective of GS2 in the syllabus, right? So what is the mediation? First of all, when we talk about mediation, how do we understand mediation? Mediation is nothing but if in a dispute, let's say you and your friend get in a dispute and a third party comes in between you two trying to resolve that dispute, wherein the third party which is there, a third friend who is neither supporting any one of you but is interested in resolving the disputes between you two, so that both of you all don't fight, and that third party is able to get the facts out from you, and you are able and he facilitates you to both of you to arrive at a consensual dispute resolution. This particular mechanism is known as the mechanism of mediation, where one does not go to the court to resolve their disputes. What they do is they try to resolve their disputes amongst each other with the help of an impartial person who helps them resolve this dispute, who is known as the mediator. So it is a process where an impartial third party, right? So the key word for that third party is impartial, where he or she is not there to take any one party's side and is there solely with the objective of helping both parties to resolve their disputes, appointed to facilitate structured negotiation between the disputing parties and help them reach a mutually agreeable settlement. So if both parties who are in dispute with each other get to resolve their disputes and reach a settlement, would that not save their time to go to court, right? So that is the purpose of mediation. It is known as an alternate dispute resolution mechanism, or ADR, right? So if you see this name floating anywhere, you can put mediation in the bracket. What is alternate? Since it's an alternative route to dispute resolution, one does not have to go to the court. That is why the name alternative dispute resolution, or right, as an alternative for litigation in courts. So this is the concept of mediation, and the International Convention on Mediation is known as the Singapore Convention, to which India is a signatory, which is known as the Singapore Convention on Mediation, which assures disputants that their mediation settlements will be enforced without much difficulty across the world. So this international document takes place of takes charge of enforcing the mediation settlements across the world. That is why this is an important piece of international law on the subject of mediation, to which India is a signatory of. And that is why whenever a country signs an international document, what it does is in its own country, it comes and promulgates a domesticated domestic law on that subject. So the domestic law on this mediation subject is the newly promulgated Mediation Bill, which has come out in the past few years and it is being discussed. So in the process of discussion, whenever a bill comes in, it goes into the Parliament, wherein the other committees of the Parliament discuss on that bill, right? It tries to reason out what the committee thinks are the good points and bad points with respect to the bill. So this is the stage at which the mediation bill is currently at right now, and that is what the article talks about. As to this parliamentary committee has flagged out certain issues of those bill. So let's first look at the important provisions of the bill, and then we'll try to take a look at what are the issues that are being flagged by the parliamentary committee. So the key features of the draft mediation bill are that it first of all aims to enforce domestic and international mediation settlement agreements and provide for a body for the registration of mediators, encourage community mediation, and make online mediation an acceptable and cost-effective process. So as we can see, this mediation bill is there to ease the process of mediation in the country, wherein it would facilitate people to carry on mediation. It will provide for a body for the registration of the mediators and take care of all the activities in and around the mediation sector. So the draft bill proposes for pre-litigation mediation, at the same time safeguards the interests of the litigants to approach the competent adjudicatory forums or courts in case an urgent relief is sought. What this means is that the bill tries to make mediation a step mandatory before litigation. Because what happens is that whenever two parties come into a dispute, they instantly go to the court, and which is why the pendency of cases is rising in the courts a lot. So in order to decrease this and in order to give the parties a chance of resolving their disputes mutually, the mediation is being kept. The bill proposes that before the parties get to go to the court, they have to mandatorily perform a mediation first. They have to go through a mediation process first, because if in that process only they get to resolve their disputes, then they needn't go to the court. So that is why the pre-litigation mediation has been kept mandatory by under the mediation bill, which means that the disputing parties before going to the court will have to try to solve the dispute via the mediation route first, right? And the successful outcome, if via this mediation the parties arrive at a mutually agreeable settlement, this would be taken out in the form of a mediation settlement agreement and has been made enforceable by law. So this also needs protection. If two parties do resolve their disputes and come at an agreement, they need to sign that agreement. This would be known as the mediation settlement agreement. Now this agreement needs to be recognized. Otherwise, today an agreement has reached, and after a few days one party thinks that this agreement is detriment to me, he or she might not accept that agreement. So in order to protect this and to safeguard the mediation settlement agreement, the bill will make that agreement, it will recognize it and make it enforceable by law, which means that the parties who arrive at a solution will not be able to dispute that agreement. If they sign to that agreement, they will be binded by that agreement. That is the feature of the mediation bill. And this mediation process protects the confidentiality of the mediation undertaken and provides for immunity in certain cases against the disclosure. In a lot of cases, the mediation which goes on in the parties contains the disclosure of certain confidential facts or factors which both parties might come to know of, and even the mediator also might come to know of. So in this case, the mediation bill protects the confidentiality, and which means that anything that is said in the mediation process should be kept confidential and should not be disclosed to any other parties. So the concept of confidentiality is also incorporated in the bill, and it provides for establishment of the Mediation Council of India. This is that council which would be the body for the registration of mediators, who would assign mediators to particular cases, who would take care of the mediation caseload. All this would be the body, the Mediation Council of India, dealing with all of these issues, which would be headed by a retired judge who would be the chairperson of this Mediation Council of India. And then it also provides for community mediation as well, which means that not just two individuals resolving their disputes, but let's say there are communities who have disputes which need to be resolved. Let's say, for example, we saw yesterday the issue of protecting the khijri trees. So the whole Bishnoi community is there to protest against the felling of these trees, and at one side were the Manufacturers Association of the solar plants. So both these communities can come together and resolve their disputes, which is what was done yesterday, right? Wherein we saw that an agreement was brokered by the administration between the solar plant power plant manufacturers and the Bishnoi community leaders, who agreed that no trees would be cut, and if any trees were cut, a fresh tree has to be planted elsewhere. This is a case of community mediation, right? So these are the certain features of the draft mediation bill. Now coming to today's article, what are some of the issues that have been flagged by the Parliamentary Standing Committee on Law and Justice? So this is also an important committee in the Parliament, since it's a deliberative body on and takes care of the legislature of the country. The committees are set up to scrutinize the bills that are promulgated in the House before they become law. So they have flagged out certain issues. The first issue which the committee points out is that this pre-litigation mediation being made mandatory is being flagged out as an issue, which means that if one keeps the mediation process mandatory before going to the court, the committee feels that this might result into frivolous mediations as well, wherein in order to lengthen the process of justice delivery, people who are interested in delaying the process might get into mediation and try to lengthen the process of justice delivery over there. So this is one of the issue being flagged out, where it says that this making the pre-litigation mediation, which means that mediation before one goes to the court should not be made mandatory, and it has already been made mandatory under the Commercial Courts Act of 2015. So the committee says that under that act, if you've made it mandatory, the results of making pre-litigation mediation mandatory should be checked, and then this particular clause should be added to the mediation bill. So that's the first issue which the committee highlights. Then the second is that the Supreme Court has been given the power to frame rules with respect to that mediation which the court has ordered. The committee points out that the Supreme Court should not be given the authority to frame rules, because the rule-making power essentially rests with the Parliament, which is the legislative body, and Supreme Court, which functions as the judiciary, which means that it is there to interpret law, and its form of law-making occurs from the judgments that it's make. So it flags out as an issue that the court's mandated mediation, the rules for the same should not be given to the purview of Supreme Court. That's another issue which the Parliamentary Committee flags off. The third is that it questioned the non-applicability of non-commercial disputes involving government and its agencies. So currently mediation is there for the commercial disputes, those disputes which involve a transaction and are the disputes are of commercial in nature. Those are kept under the purview of mediation. But the bill has removed the non-commercial disputes. Let's say, for example, what happened during the farm laws agitation, where it was a dispute between the government and farmers with respect to the farm laws, which was not commercial in nature. So they could resolve this dispute via mediation. But under the new mediation bill, this kind of non-commercial disputes which involve government, that has been kept out, which the committee has flagged out that this should not be done. The non-commercial disputes which involve the government should also be taken under the purview of the mediation bill. And the fourth is that the chairperson who will head the Mediation Council of India should be of proven quality and selected by a selection committee appointed by the center. So his appointment and his or her appointment should also be done in a structured manner, which would be done by a selection committee, which would be instituted by the center. So these are the four main issues which the Parliamentary Committee on Law and Justice highlight on the Mediation Bill. So this becomes important for us, and this was the discussion with respect to the Mediation Bill. With this, let's move on to our next article for the day. The next article which appears in the newspaper reads, India set to beat China in population, says a UN report. Finally, we have something which we can beat China on, and that is population. So, for our examination point of view, this report becomes important. So, which is this report? So, the 22 edition of the United Nations World Population Prospects, or the WPP report. This is published by none other than the United Nations, and it is a very reputed old report. It was published on 11th July 2022, which is also the International World Population Day, right? So on that occasion, the United Nations World Population Prospect Reports was released, and what are its major outcomes or major highlights of the report? It is projected that India will surpass China as the world's most populous country in 2023, right? So the last measured population of India was 1.2 billion in 2011, and it is set to surpass China in the year 2023. So this is a major highlight which the World Population Prospect Report by the UN says. Then secondly, it says that it also projected the world's population to reach 8 billion on November 15, 2022, which means that this report is highlighting that the world population is on a continuous rise. The population is continuously increasing, and currently the world population was said to be around 7 billion, which is set to reach 8 billion in this year itself on November 15, 2022. This highlights the rapid increase of population which is going on in the world. And this growth of population, the report analyzed that it is not uniform. The most growth of population is happening in the developing or the least developed countries, that of Africa and Asia. These are the regions where most growth of the population is being seen, and not in the developed countries. So the UN said that more than half of the projected increase in global population up to 2050 will be concentrated in 8 countries. And these 8 countries are situated in either Asia or Africa. So Congo, Egypt, Ethiopia from Asia, and Nigeria, and India, Pakistan, Philippines, and Tanzania again from Africa. So these countries, these 8 countries from Africa and Asia are going to be the centers which will see the increase in population. So this also tells us that the increase in population is not uniform around the world, it is concentrated in certain countries. So these are the highlights with respect to the United Nations World Population Prospects Report, which are important for us. With this, let's move on to our next article for the day. The next article which appears in the newspaper reads, Andhra Pradesh's Godavari Delta in the grip of floods. Now due to the incessant rains which we have been seeing in the past few days, has resulted into flooding of the Andhra Pradesh region. Because of the dams which are situated on Godavari river, the dam capacity has overflowed, and now the excess water from these dams is released. And due to those release of those dams, excess water is seen in the cities and floods occur. So in this aspect, we'll look at river Godavari, which becomes important for us from the examination point of view, about the origin of this river, the tributaries, and certain important points. So about river Godavari, where does it rise from? As we can see, it rises in the Triambakeshwar hills of the Western Ghats, again which is near Nashik, and flows from Maharashtra to drain in the Bay of Bengal. So it is the largest river in peninsular India, and it is known as the Dakshin Ganga, right? So Ganga is there in the north, and Dakshin means south. So the Ganga of the south, that is the longest river of peninsular southern India, is known as the Godavari or Dakshin Ganga, right, or Vriddha Ganga, or what is also called as Old Ganga because of its age, size and length, and it is navigable in the delta region. Source of origin of the Godavari river, as we saw, rises from a place called Triambak Hills located in the Western Ghats in Nashik district in the state of Maharashtra. And the confluence or mouth of the Godavari river, where does it drain? It drains in the Bay of Bengal before forming a large delta below Rajamundri, which means that before draining it forms a large delta. And the Godavari basin extends over states of Maharashtra, Andhra Pradesh, Chhattisgarh, Odisha, in addition to smaller parts in MP, Karnataka and the Union Territory of Puducherry, having a total area of 3 lakh square kilometer. So 3 lakh square kilometer is the area of its river basin. River basin is the area covered by the main river and also its tributaries. Together the area which they cover is known as the river basin. So which are the major tributaries of Godavari? The Pravara, Indravati, Vainganga, Vardha, Pench, Kanhan, Penganga, Manjira, Bindusara and Sabari rivers are some of the important tributaries. Can we locate this in the map? Here is where Godavari rises, and those tributaries which join in from the left hand side are known as the left bank tributaries. So tributaries such as Purna, Penganga, Vainganga, Indravati, right, Sabari, these are joining from the left to the river. The river is moving like this and it is joining from the left, that is why these are left bank tributaries. And Manjira, Pravara, Manyar, these are the right bank tributaries. So these are some of the important tributaries of the river Godavari, right? So this was a discussion today with respect to the important articles for the day. We'll meet again tomorrow with the important articles from tomorrow's newspaper. Thank you.